I'm criminal defense attorney Neil Shouse with Shouse California Law Group. Most of the time, when someone gets drunk or takes intoxicating drugs or medications, they are fully responsible for their actions under the law. But, believe it or not, in certain situations, being intoxicated can actually be a defense to a crime. There are two types of intoxication defined by the law: voluntary and involuntary. Voluntary intoxication is when you knowingly consume alcohol or drugs. This can be used as a legal defense in situations where the prosecution must prove you intended to commit the crime. For example, if a drunk person accidentally grabs the wrong jacket when leaving a bar, then they have not committed the crime of theft, because theft requires the intent to steal. Similarly, the crime of murder requires an intent to kill, and many fraud or forgery crimes also require intent. For all of these crimes, intoxication can be a legal defense if the accused did not intend to commit the act. But voluntary intoxication will not help in general intent crimes like DUI or battery. For those, the law only looks at whether you committed the act, not your mental state. However, don't assume you can just get drunk and commit one of these crimes with no legal consequences. Prosecutors, police, and juries have little sympathy for drug or alcohol use, and often it's a dangerous and lengthy legal battle to fight charges with an intoxication defense. But then there is what's known as involuntary intoxication, which is when you are drugged or forced to consume a substance against your will. Involuntary intoxication can be a complete defense to any crime, meaning you usually cannot be prosecuted because your actions were not your fault. If you or a loved one is facing criminal charges, call us for a free consultation at 855-999-7755. We will fight to get your charges reduced or dismissed.